John and I actually did one of these estate planning seminars together. Would have been the Mississauga Convention Center back in 2018. 250 people in a room, everyone's sitting by tables. I don't think we're going to be seeing that again this year or next year. But, those events were nice, a nice dinner, glass of wine. These events are a little bit more convenient. You can still have your glass of wine, convenience from your own home. So, that being said, as the last few people start trickling in, I am extremely excited to have Jon Hreljac presenting to us tonight. Tonight's planning session is called Estate Planning Beyond the Will. So we are going to be covering concepts like the will, powers of attorney, probate, executorship, transferring assets, techniques to reduce probate. As always, all of the slides are going to be given to you after the presentation, a copy of the recording. We've got a great number of additional resources, a will checklist, an executor's duties checklist. Jon Hreljac is the head cheese at Manulife Financial, Manulife Investments. So this is the estates taxation. He is an advisor resource. So when someone like myself or one of the advisors at Guided Wealth have a question about taxation, trusts, and estate planning, we have Jon as our resource. So it's a fantastic opportunity to have him speaking directly with you, and we'll make sure to get questions answered at the end. During the presentation, if you do have a question, please use the chat function. There's myself, Joel, Omar, Susan, a bunch of the Guided Wealth Management team here. We can address those questions. We don't want to interrupt during Jon's presentation, but at the end, there is an open Q&A. Use the raised hand button, and I'll unmute you, and you can ask your question directly. So that being said, we'll get right down to it. We want to make sure everyone gets their full presentation. So I will slide off. And if anybody had a question, to get to the chat function, you scroll down to the bottom of your screen, and it's right in the dead center. So your chat function will be sent to the panelists. If you want to make it available for everybody to see, you just change that to column from all panelists to all panelists and attendees, and then everybody can see your question. So let me mute myself, and I will pass it on over to you, Jon.
Okay, perfect. Thank you very much for the kind words, and welcome everybody this evening. Thanks for taking some time out of your schedules on a Thursday night to do a little, self-learning and hear a little bit about wealth transfer and estate planning 101. I really like this presentation. I go across the country delivering this information to clients and even to advisors alike, setting the stage about what it means to transfer wealth from one generation to another, and some things to think about, beyond simply the will. Given what's happened to our world in the last year and a half, given the COVID pandemic, estate planning, wealth transfer has always been, topical. That being said, I think I've seen a huge uptick in terms of, people really, putting this topic at the front of their mind. To think about, what happens when it comes time to move money, typically from one generation to the next. A lot of people's worlds are upset. The steady Eddie lifestyle people, were leading, have also been upset. So this has been a great time to really think about, the unknown and ultimately the transfer of wealth, given the COVID era. And like I said, it's always been topical, but I've seen a great uptick. So this information should be good for you to consider on a go forward. I like this presentation because it's, relatively easy to communicate the message. But that being said, I'm well aware everyone has their own specific needs and wants when it comes to their estate plan or wealth transfer. Family dynamics are different across the board, whether you're in a long-standing first marriage or if you're under a third or fourth marriage with multiple children, with multiple partners. I've seen it all, right? It makes things complicated. So I try to speak to things that are relatively universal. But again, I'm well aware that if people have their own specific needs or wants, and I'm happy to address questions at the end of the presentation. So at the end of the day, I'm just going to touch on a few things. for formal remarks, a couple of strategies, some mistakes, the executorship, for some techniques to avoiding probate. But let's just hop right into it. So I always like starting this presentation with a very simple strategy. And it's the only strategy I'm really going to speak to. And this really is the concept of choosing your beneficiaries carefully. Okay. And really, this is the crux of wealth transfer, in my personal opinion. But in order to understand what a beneficiary, in order to understand the strategy, you need to understand what a beneficiary is. I think most people understand that, but in case you don't know that term, a beneficiary simply is somebody who will receive your stuff when you pass away. And when I say stuff, I literally mean anything. It could be your real property, your house. It could be your investment portfolio. It could be, your RSP, TFSA, or what have you. It's someone who's going to receive your stuff, and it can be done through your will, and it can also be done through a beneficiary designation on a plan. There's two different ways to transfer wealth, but that's what a beneficiary is. And also, in order to understand this strategy, you also need to really understand, what actually happens to your assets when you pass away from a tax perspective. In other words, what does CRA tell you, or tell your executor, or tell your estate? And typically, if I'm in a live audience, I poll the audience, and in terms of I ask that question, what actually happens? Does anyone know? And I would say 90% of people really have no idea what happened to their assets from a tax perspective when they die. So what that means to me is that 90% of people probably might not have a sound estate plan because they actually haven't thought about it. So I'll tell you what happens. When you pass away, what CRA says to you, or says to your estate effectively, is that you're deemed to dispose of your assets at fair market value immediately before death. So if you think about it, what does that mean? Deemed disposition basically means it's as if you went out and sold everything you owned immediately before you die. Okay. So if you think about that, if you were to do that during your life, tomorrow you got up and said, I'm going to liquidate everything I have, sell everything, liquidate my RSPs, liquidate my RIFs, what have you, what's that going to lead to? That's likely going to lead to a big tax bill, right? You're going to have a big income inclusion. You're going to trigger capital gains. RSPs or RIFs are fully taxable. So basically, you're taking a bunch of income into your or on your tax return in one given year, if you were to do that in real life. So that also same principle applies when you pass away. You have this big income inclusion, right? That being said, that whole concept of deemed disposition at fair market value when you pass away is basically under the presumption you're leaving your assets to anyone other than a spouse, okay? Now, when you're doing your planning and you leave your assets to your spouse when you pass away, there's a provision in the Income Tax Act that allows for a spousal rollover, which basically means your assets can transfer to your spouse on a tax-deferred basis. So they transfer at cost. Therefore, no tax implications when leaving assets to a spouse when you die, which sounds pretty simple, right? Because a lot of people, when they do their estate plan, wealth transfer strategy, they say, when I die, everything's going to go to my spouse. And when my spouse dies, everything's going to go to me. So really, it's not going to have any tax consequence until the death of the second spouse. That being said, again, kind of going to my opening comments, in my personal experience, those long-standing, first marriage scenarios are much more few and far between, to be honest, right? I've seen many second, third marriage scenarios, blended families, high net worth individuals, and they think to themselves, I'm doing my estate plan, doing some wealth transfer strategies, and as much as I love my third wife, when I pass away, I would love for some of my assets to go directly to my kids from my first marriage, my biological kids. I still want some assets to go to my spouse, but I want to make sure my kids from my first marriage are also taken care of, right? So that's really where the whole concept of choosing your beneficiaries carefully comes into play, okay? And the way I look at it is that clients effectively have, what I say, two piles of assets. You have your tax-unfriendly assets that will trigger tax at death unless you leave them to a spouse, or you have your tax-friendly assets that really doesn't matter whom you leave those assets to, but really they should go to your kids as an example, or any other beneficiary. So your tax unfriendly assets, these will trigger tax at death unless they go to a spouse. So that basically boils down to your RSPs, your RIFs, or any asset with an accrued capital gain. So perhaps your non-reg investment portfolio, maybe your rental property that's only in your name or what have you. But when you're doing planning, right, those assets should go to your spouse, all things being equal. Now, your assets that are what I say tax paid or tax friendly, it doesn't matter who you leave these to. Cash, GICs, money market funds, no tax consequence at death in terms of income tax. Those type of assets could go to your kids or to your spouse. You don't have to worry about tax whatsoever. So it's kind of it's important to look at those assets and who's getting what, especially in those circumstances where you have assets flowing to a number of different individuals, including your spouse, okay? Your tax-friendly assets to your spouse, your tax-friendly assets to anyone other than a spouse can save or defer a lot of tax upon death. Last point, TFSAs, tax-free savings accounts. That's what it stands for. You see that in the middle down at the bottom. TFSAs are a beautiful investment tool. The strategy here, though, is that with the TFSA, the death benefit from a tax-free savings account is going to be tax-free, regardless if you leave it to a spouse or to a child. But with a TFSA, you can name a spouse as a successor holder, okay? And only a spouse can be a successor holder. And what that basically does, it allows the spouse to effectively assume ownership of that TFSA, okay? And even if your spouse has already maxed out their own TFSA, because you can only contribute, so much to a TFSA in any given year, and the maximum amount you could have in a TFSA without any growth is about $75,000 at this point in time. But let's say you max out your TFSA and your spouse has maxed out their TFSA. That surviving spouse can effectively combine the two accounts and have 150 grand in their TFSA upon the death of the first spouse. You have a supersized TFSA by naming that spouse a successor holder. A great, great strategy. You can name your child as a beneficiary of a TFSA, but your child will receive that death benefit or receive the cash, but they would need their own TFSA contribution room to have that money to go into their TFSA. Absent that, they would just receive non-reg money or invest it from a non-reg perspective. Therefore, having that spouse named a successor holder is a great strategy that you have to consider when it comes to your TFSAs. So those are some tidbits on choosing your beneficiaries carefully. Lots of things to think about. Have that conversation with your advisor. Look at your accounts, see who's getting what, and think about those tax consequences upon death. It can go a long, long way. So carrying on, I'm going to kind of shift gears here a little bit and make some comments really about some common mistakes or some strategies around what things that people need to do when it comes to their estate plan or wealth transfer strategy. And really at the end of the day, the most common mistake in Canada, without a doubt, believe it or not, is simply the failure to have a will, okay? The stats are there to prove it. Approximately 52% of adult Canadians do not have a will. This is widely published, which translates to about 14 million people walking around in Canada without a valid will. Very important to have a will, right? There are many things you can do to minimize estate assets or assets inside of the will, which is a good strategy, which I'll get into later. But at the end of the day, a will is the backbone of an estate plan. Very important to have that will, right? At the end of the day, this dictates how your wealth is going to be distributed. And you need to have those conversations with a lawyer to get that in place. Well worth a few $100. It's typically not that expensive to have those conversations to get your ducks in a row. Now, I always like to show an example what it looks like to die without a will, just to kind of give you a flavor as to what happens and why it's so important. And the concept of dying without a will is called dying intestate. Okay, so dying intestate means dying without a will. It's kind of a universal concept. Now, if you die without a will, guess who gets to determine what happens to your assets? Well, it's determined by the government of Ontario, really based on the intestacy rules or a bloodline test. And in my opinion, it's not a good result, and I'll show you why in a second. And this kind of proves my point why how important it is to have a will in place. So what does it look like to die without a will in Ontario? Well, I always show this simple example. Let's assume we have Janice and Joe, and they have two kids, Jack and Jill. Okay, Janice and Joe are a married couple. And Janice happens to pass away without a will, but she has $1 million in her name and her name only. Okay, so no joint ownership over this $1 million, no rights to survivorship. So what happens under the intestacy rules in Ontario if she dies without a will? Well, in Ontario, there's something called the preferential share of one's estate. And what that means is that the surviving spouse receives that preferential share. And the preferential share in Ontario is the first $350,000, which recently just increased from $200,000 in the last few months. So what happens here is that Joe, the surviving spouse, gets the first $350,000 out of Janice's estate, and the remaining $650,000 is then split equally amongst the surviving spouse and surviving kids. So you can kind of see here for yourself in the slide who ends up with what. Joe getting about $500,000 and the two kids getting about $200,000 each. And so I always kind of say to people, if this was you, would you be happy with that result? Maybe, maybe not. I would say 99% of the time the answer is going to be no for a variety of reasons. So number one, this doesn't take into consideration the tax consequences of assets that are changing hands. So kind of going back to my first point about choosing beneficiaries carefully. So this could result in tax consequences or very punitive tax consequences. So that's important. But number two, and maybe even more importantly, it doesn't take into consideration family relationships. The intestacy rules don't discriminate between, family members, or if Janice liked one child more than the other, or so on and so forth. So in this example, what I failed to mention from the outset is that, although Joe and Janice are still legally married, they actually separated about 10 years ago, never got officially divorced. But guess what? You still fall into the intestacy rules. They haven't talked for 10 years, but Joe was still ending up with a $500,000 windfall. And as part of that marital breakdown, Jack and his mother had a falling out. Jack moved to BC and hasn't spoke to his mother for about 10 years. Meanwhile, Jill was a caretaker, very close with her mother. But guess what happens? Jack still ends up with about $200,000 and Jill ends up with $200,000. Bad result, right? Obviously, if Janice had her will in place, she would have ensured something like that would not have happened. So very important that you don't rely on the intestacy rules to distribute your wealth, especially when you have, those family relationships that have been, broken over the course of time, because, obviously that would not have been her intended result. So very important to get that will done. Last point about wills in Ontario, or the intestacy rules, is that the intestacy rules do not apply to common law partners, okay? Which is I think, a very important point, because I know of a lot of people, myself personally, throughout my life, that have never been married, but are in a marital relationship because they've lived with the person for 10, 15, 20 years, but never officially tied the knot. And guess what? If that person were to pass away without a will, that marital or that common law partner would effectively be out of luck in terms of receiving any assets from that person's estate, because you cannot rely on the intestacy rules to distribute assets to a common law partner, right? They only apply to married partners. So, for example, if you're living with somebody, you love them, you want to ensure they're provided for upon your death, but you're only common law, probably even more important to have a will in place in an odd way than if you were legally married, right? Because you can't rely on the intestacy rules to ensure assets flow to them. So something to keep in mind, for those of you live in common law, or, sometimes you have, older children that have been living common law, very important to consider about those points and having that will put in place to ensure their assets are properly distributed upon their death. Next point, I'm going to move a little bit quicker now. When should my will be updated? Often asked this question. Really simple answer, in my personal opinion. Anytime you have a life event, that's when you should turn to your will potentially being updated, or that be a marriage or divorce, birth or death, your kids getting older, a cash windfall, such as the sale of a business or even a lottery win, you never know, right? Anytime a major life event, think about, what's going to happen with those monies, who's going to get it, right? That's when you should turn to updating your will, having those conversations with an advisor or have you, or a lawyer. If your life is, steady Eddie, as I put it, no real change for 10, 15, 20, 30 years. I get a lot of people live a life like that. Maybe every 3 to 5 years, turn to your will, look at it. Does it still make sense? Has there been any major changes in terms of tax law, family law? I've seen wills that are, not outdated. Wills can't technically get outdated, but sometimes I've seen provisions in wills that no longer apply, which lead to confusion when people pass away. For example, they have a provision inside their will that provides for a trust for their children, but their children are now 45 years old. When that will was drafted, the kids were only like 10 or 15, right? So that leads to confusion sometimes, having provisions for a trust inside of a will when kids are grown and that trust no longer applies, right? It doesn't hurt to have it updated to remove those type of provisions. Makes things just a little bit simpler and cleaner when it comes time for estate settlement, when the executor has to deal with it. Now, what goes hand in hand with wills is a power of attorney. Okay, so really, what a will is obviously it's a document that dictates your wishes upon your death. The executor takes care of that role. The power of attorney, which I'm sure most people here know what that is, but I'll explain it to you what it is and what it means. Really is someone to act for you during your life. Typically, if you become incapacitated, in my mind. And the good news is that I've never once in my entire career have seen someone who had a will in place but did not have a power of attorney. So you have a conversation with a client or with a lawyer to have your will drafted. The next step is turn your attention to your POA, your power of attorney. Any good lawyer will do that for you. So basically it says, when or if you become incapacitated, you have someone to act for you, whether it be for your property, so from a financial perspective, or for personal care. So number 2 or 3 on the list is really the most popular ones you'll see. The POA for property is very important, again, for someone to take care of your financial matters. If you became, typically mentally incompetent, you can have specific provisions in there to allow a POA to act broadly or specifically. I always think a broad POA in terms of their power is appropriate, so they could act as they see such. But always, obviously the person who's going to be acting for you is likely hopefully someone you trust a lot, typically a spouse, or typically an adult child. Sometimes a spouse isn't the best choice, especially if you're older, because that spouse could become incompetent, right, and not be able to act. Typically, POAs tend to be appointed to someone that's younger, or you have a successor POA in place in case the primary POA is incompetent before you become incompetent, right? So very important to have that in place for property. Similar with personal care, wishes in there in terms of what happens to you with end of life decisions. That's where an advanced directive can come in play as well. But both important to have in play. Again, you have your will done. POA is next step. Very important documents to have done. The last point I'll really mention with POAs and wills, and I think this is super important and definitely overlooked. For those of you who have property in different jurisdictions, so my example is, say you live in Ontario, where I'm from, but you have a condominium in Florida, like a lot of people do, or if you're lucky enough. If you have foreign property, or even a foreign property in a different province, but you live primarily in one province, very important to have a POA and a will done in that foreign jurisdiction. Especially, again, if we're talking about, say, Florida or a different country. Very often, a foreign jurisdiction will not recognize a will drafted in Ontario or a POA drafted in Ontario. So, for example, if you pass away or become incapacitated and need your POA or executor to act for you and deal with that property in Florida, but you don't have that POA or will done in that foreign jurisdiction, they're going to be out of luck or going to have to jump through a lot of hoops to get that done. Okay. Again, because the Ontario POA or will not be recognized in all likelihood. So makes sense to spend the extra few $100s to have that done for your foreign property. So keep that one in mind, because these documents, don't obviously apply universally. They're really specific to each individual jurisdiction. Next point I'll bring up, beneficiary designations. I bring this up because I did mention when people, have life events, for example, they may turn to updating their wills relatively quickly, but sometimes you forget about beneficiary designations. So beneficiary designations can be on an RSP, a RIF, a TFSA, pension monies that basically say when I die, this person gets these monies directly from that plan, right? So any type of plan or investment that has a beneficiary designation, typically the will is silent on it. There's no mention of it because it's outside of the will, outside of the estate, which is an awesome planning tool. Therefore, if you're updating your will, make sure you also update or review your beneficiary designations on all your plans. You always want to ensure your entire estate plan, when I say speaks to each other, okay? Sometimes people, again, will update their will and they don't update their beneficiary designation. Could be a bad result. It's just something you don't want to forget about. So it's just a quick reminder from that perspective. And I like to show a simple example, what it kind of looks like sometimes when you don't do proper planning, okay? And really, this is the whole concept of, when I say treating equal beneficiaries unequally. So what we have here, we have a widower situation, and he's got 3 kids and 3 assets. And he's doing some estate planning, wealth transfer. His 3 kids and his 3 assets are all worth the same. He has a $1 million RSP, he has a $1 million house, and he has a $1 million non-reg mutual fund portfolio. So he thinks to himself, well, this is great. This is so easy. My estate plan is simple. 3 kids I all love equally, 3 assets all worth the same. Each child is going to receive 1 asset each upon my death, okay? So what happens if he decides to do this? Well, this is what's going to happen, okay? So he has a son, Jason. Jason's going to receive the RSP, okay? With an RSP, you can name a beneficiary directly on that plan. So the father passes away. Jason receives a $1 million check from the financial institution. Thank you very much. He's taken care of. He hops on a plane, goes to Australia, what have you, never to be seen again. Luke's going to receive the house, okay? The house is going to flow through the estate, but there's something called the principal residence exemption that will apply on the house. So no tax to be paid in the house. So Luke effectively receives this $1 million house, tax-free, and he's effectively taken care of. Now, Kim is going to receive that $1 million mutual fund portfolio. As you can see on the slide here, it only says $500,000. So why is that, right? Well, what ends up happening is that I'm going to turn your attention back to that $1 million RSP that Jason received. So although Jason received that $1 million RSP, right, there's no tax deferred rollover here. It still has to, the estate is still on the hook for the tax. So there's a $1 million income inclusion in the estate for the value of the RSP, although Jason already received the check. So the executor is sitting there thinking to himself, where is the money going to come from to pay for this tax on the RSP? About $500,000. Well, typically it's going to come from the most liquid asset inside the estate, right? The mutual fund portfolio, you cannot name a beneficiary directly on it. It has to flow through the estate, become an estate asset before being distributed to Kim. That is where typically the money is going to come from to pay for the tax on the RSP, right? So what ends up happening in a situation like this is that Kim, who was supposed to receive that mutual fund portfolio, is effectively flipping the tax liability on the RSP and ending up with half as much as her 2 brothers. So obviously a very terrible result. Jason and Luke, they could be nice brothers. They could true up the estate, cut Kim a check for, $200,000, whatever the number would be. Never happens, right? Greed enters the picture very quickly, despite the fact, how much you think your kids may, love each other, like each other. I've seen situations play out like this in real life. Kim could sue, litigate, make an argument that was not the intention of the father in this case, and let the court sort it out. Maybe she wins and maybe she doesn't. I don't know. So long story short, if you're planning to treat your kids equally, make sure you are, right? Always take into consideration the after-tax consequences of distributing assets to these individuals, right? Have those conversations with your advisor. A couple quick solutions to this, problem. Number 1, You could obviously name each child a 1/3 beneficiary of each asset. That would solve it. Number two, maybe you have a life insurance policy in play, right? That will pay into the estate to cover the tax liability on the RSP, right? Plan for the tax liability on the RSP. You pass away with the big RSP, big RIF, no rollover to a spouse, it's going to be a lot of tax, right? Or is it going to come from to pay for it? Well, life insurance can work as well. So I like that example. So keep that in mind on a go forward. I'm just going to turn your attention now to a few more comments around the role of the executor in the Ontario probate process. I think this is very important information. 6-7 years ago now, there was some big changes to the executorship and probate process in Ontario that, believe it or not, a lot of people still have no idea that they exist. So I'm just going to have some comments around that and then kind of transition that into some techniques to avoiding probate, okay? But in order to understand this conversation, you really still have to understand or know what probate is. I think a lot of people have heard of probate, but maybe they actually have no idea what it is. And what probate really means at the end of the day is the application made to the court, or the process of having the will validated by the court. Okay, so in other words, when someone passes away, presumably they have a will, hopefully, and presumably the executor under that will, right? The executor is someone who's appointed to effectively take care of the estate, knows where that will is. They take that will to the courts to have it validated by the court, okay? To basically prove that is indeed the last will and testament of that individual. The executor is who they say they are under the terms of the will. Assuming all goes well, which may take 1 to 3 months to have that done. It doesn't happen automatically or overnight. Of course, everything is a slow moving machine when it comes to this type of stuff. Once that's done, something called a certificate of appointment is issued to the executor, which basically will now allow him to carry out the terms of the will, okay? Why is probate required? There's a couple reasons. Number one, a lot of financial institutions, for example, will not release funds to the estate or to the executor to deal with if they're over a certain threshold, typically over 100 grand, without having a probated will, right? Because there's risk to the financial institutions to, obviously release money without proof of this person being passed away, as well as, proof that that the executor is who they say they are, and everything is, on side there. So that's why a probated will is needed. Number two, to transfer real estate from the deceased to an estate, or from the deceased to a beneficiary. The land registry system requires a probated will typically, or if nothing else, the executor does it for, to protect themselves from potential liability, right? Many reasons why a will need to be probated. Not every will needs to be probated if you're dealing with, say, a smaller estate, but a vast majority does, okay? Vast majority do. That being said, nothing in Ontario is free, of course. Neither is the cost of probate, right? So to have a will probated, the fee is 1.5%, okay, of the fair market value of the assets that flow through one's estate, okay? This slide kind of explains it here. For the first 50 grand, there's no tax, okay? So basically the first $50,000 of estate assets, which isn't a heck of a lot, there's no fee. Everything over and above $50,000 is a 1.5% fee. So to kind of give you an idea what exactly that means, if you were to pass away with $1 million of estate assets, this is Ontario. I realize there are people throughout the country on this call. In Ontario, anyways, you're going to be subject to $14,250 of probate fees, which really is additional tax at the end of the day. Every province differs slightly in terms of their probate fee. Ontario is on the high side. Quebec, for example, doesn't have probate. But, since I deal primarily with Ontario advisors and Ontario clients, this is what I speak to. So again, this 1.5% doesn't sound like a lot on the surface, but if you pass away with a rather large estate, say $5 million, you're looking at $75,000 of probate fees. That's $75,000 less going to your beneficiaries in terms of after-tax dollars. And that being said, the way real estate prices have absolutely gone through the roof in Ontario, and I think across the country for that matter, it doesn't take much now to have, a $2 million home anywhere, it seems. So you pass away with a home, right, that's valued at $2 million. You're going to be looking at, $30,000 of probate fees on its own right there. So the strategy is there to minimize that probate fee. And keep in mind, probate has nothing to do with income tax, right? Income tax driven by the feds is in play as well, right? The highest marginal tax rate is 53% in Ontario. So you're paying tax at a high rate when you pass away. If you're in that high rate, then you tack on an additional 1.5% of probate fee. All of a sudden, those estate assets are just getting, completely, taken down by tax. So I think it's still very important to plan around probate, and there's things you can do to avoid that. A couple other quick points about probate. In Ontario specifically, there were some changes, like I mentioned, 6 years ago that came into place. Really what this change was heightened requirements by the executor or on the executor to file something called the estate information return that is due 180 days after the date of probate. Okay, so what this basically means, if you are an executor or if you're appointing an executor under the terms of your will, this is important, make sure they're aware of the requirement of the executor to file this estate information return, which basically is a tax return filing requirement detailing all of the assets that flow through the estate and their fair market value. Okay, it's a way for the government to capture the true value of one's assets when they pass away to ensure they're getting their 1.5% pound of flesh, okay, in terms of assets that flow through the estate. Okay, there are exclusions from this. Really, it boils down to, RSPs, RIFs, TFSAs, anything with a named beneficiary. That death benefit bypasses the estate and avoids probate. Life insurance, same with that, right? There's an ability to bypass the estate there. Assets outside of Ontario and assets that are held jointly with rights of survivorship is also another strategy to avoid probate upon death. Joint ownership is a good strategy when you're doing your planning, and it can definitely work for certain assets. So think about, real estate, mutual fund, stock portfolios. Joint ownership and all works very well between spouses as well. But if you're going to be using joint ownership between children, so a lot of people think their estate plan is to add, their adult children onto their investment accounts or even their real estate to avoid probate. It can work, but make sure the documentation and the intention to explaining how that's going to work upon your passing is in place. Okay, absent having the right documentation, have the intention documented, it could lead to many problems. So joint ownership works, but it comes down to documentation and intention. As a quick screenshot to prove to you this actual thing exists, our estate information return in Ontario. There's tons of good information online if you're interested about hearing more about it. If you are an executor, if you want to explain this to your children who perhaps are going to be your executor, I think again is very important. The last thing I'll mention, what is a probatable asset in Ontario? What needs to be included? Again, I've kind of touched on it, but really at the end of the day, it comes down to real estate in Ontario, bank accounts, investment accounts. I call that the big three, right? Really, that's where the Ontario government captures their 1.5%. Boats, cars, all property, technically, everything down in the kitchen sink can be a probatable asset at the end of the day. Anything that flows through the estate. All right. So keep that in mind. You want to concentrate on doing that planning, looking at, perhaps joint ownership, perhaps looking at all your registered plans, as well as another strategy I'm going to speak to in a second, segregated funds for your non-registered money. Okay. So to wrap up, I'm going to talk about, two quick strategies as to how you could exclude assets from probate. It's also part of a really slick, wealth transfer strategy. So probate, again, avoiding probate is important because you're going to avoid that 1.5% fee, as well as, ensuring a quick wealth transfer to your beneficiaries while minimizing executor work. So how can we do that? Well, the one product I speak about a lot in my role with Manulife is something called a segregated fund. I speak about this because I'm a firm believer in utilizing this as a solution. However, a lot of clients, and I know this for a fact, have no idea what a segregated fund is. And I will explain to you what it is in a second. But I do know for a fact, though, that most clients know what a mutual fund is. So clients know what a mutual fund is, but most clients do not know what a segregated fund is. Now, from an investment perspective, they are identical. Okay, so when you buy a mutual fund, you can buy into a managed money solution, you can have a fixed income portfolio or fixed income fund, conservative fund, equity-based fund, so on and so forth. You get the exact same fund with a segregated fund, okay, from an investment perspective. But with a segregated fund, since it's issued by an insurance company, it has access to the Insurance Act of Canada, which allows you to name a beneficiary directly on the investment contract, okay? So what that means is that when you die, that death benefit from the segregated fund can be paid directly to your beneficiary, bypassing your estate and avoiding probate. With a mutual fund, you cannot do that. There's no capability on open or non-registered money to name a beneficiary directly on a mutual fund, okay? So what a segregated fund basically is a mutual fund without an insurance wrapper, okay? It allows you for that slick, smooth wealth transfer strategy and transition upon your death. Again, you cannot do that with a mutual fund or a stock portfolio. So I think this is a great solution for a sleeve of an individual's portfolio when they're talking about transitioning wealth to the next generation, okay? And perhaps the older you get, the more you dollar cost average into a seg fund, right? Because you're planning for that wealth transfer strategy. So that's what a seg fund is. You know, when I speak about the benefits of a segregated fund, you know, we already talked about the ability to bypass your estate, therefore avoid probate and other estate fees that might come along. So that's number one. I talked about these big 5 benefits. Number 2, there's creditor protection features with segregated funds, both in life and in death. So if creditor protection is important to you, depending on, say, you know, your line of work, or or whatever the reason may be, look at segregated funds as an option. Seg funds also help protect challenges to your will, right? As a very simple example, I've come across scenarios where I'm dealing with, say, an individual, an older widow. She has 2 kids. She's doing some planning. She goes to me, she says, John, you know, I've got 2 kids, I love them equally, but when I die, I know for an absolute fact, my daughter is going to challenge my will, right? She resents my son or her brother. You know, if nothing else, it'd be a pain in the butt. She thinks she deserves more. So if that happens, if a will's challenge, it's going to take months, if not years, for that estate ever to be settled, for that son to ever get money from that estate, right? And the best of times, it takes, you know, say 6 to 9 months to settle an estate, let alone if there's a will challenge. By using a seg fund, typically that death benefit will be paid out within 2 weeks. So in that particular situation, right, that son can get that death benefit in 2 weeks, and it's much, much, much more difficult to challenge a beneficiary designation than it is to challenge a will. So it's utilized to transition wealth on a quickly, timely basis. And lastly, it's a private transfer of wealth. Okay. What a lot of clients don't know is that a probated will in Ontario is public domain, meaning once your will is probated, anyone can get access to it. Not good, right? Especially people who are higher net worth. They want to keep things under wraps. You know, perhaps they will have specific bequests to charities or individuals that maybe they don't want everyone knowing about. Well, that's where seg funds can come into play as well, right? You can name those individuals or charities as the beneficiaries on a seg fund and remove it from your will. So something to think about. I think it's great. The last thing I speak about with the seg fund option is something called the annuity settlement option. And what the annuity settlement option is a way to control an asset beyond the grave, okay? So think about scenarios where you have, again, there's 2 or 3 kids, you know, 2 are good with money and 1 is a spendthrift, right? Just terrible with money, never really settled down, never could get their act together. If they have, you know, money, they go spend it and blow it quickly. Maybe they suffer from, you know, substance abuse problems, so on and so forth. So you want to control that asset beyond the grave. So you can do that with a formal trust, okay? Set a trust up. That works, but you have to get lawyers involved, There's expenses there, perhaps trustee fees, tax return and filing requirements. So trusts work, but again, clients don't love the idea because they don't want to go down that road. So the annuity settlement option can be used in conjunction with a seg fund as a cheap or free alternative to a formal trust. And what it effectively does is that it says when you die, right, instead of your beneficiary receiving a lump sum death benefit like they normally would from a seg fund, they're going to receive an annuity. Okay. And that annuity will simply be paid out over the course of time, whether that be over the life of the beneficiary, over a certain term. You get to choose how it's paid out, right? So you're controlling that asset beyond the grave. It's that cheap or free alternative to a formal trust. As a very simple example, you may invest $1 million in the seg fund. You have 2 kids, daughter, financially responsible, no problem with her receiving that lump sum death benefit upon death. The son, you want to treat them equally, but he's terrible with money, cannot be trusted. He's going to receive the same 500 grand, but it's going to go directly into an annuity. So that 500,000 will be paid out slowly over the course of time, right? Don't have to worry about him blowing it all at once. You can control that asset beyond the grave. So we've had a lot of success with this strategy over the course of time because it simply is that alternative to a formal trust. There's no other way of doing it, no other way to have that control beyond the grave. So that's the seg fund. The last thing I'm going to speak about, my last slide here, and this is, I think, is also another alternative or another way to avoid probate at death. This is more of a specific strategy for those that are 65 years or older, but this is something called an alter ego or a joint partner trust, okay? And what an alter ego trust effectively is something, again, you need to be 65 years or older to establish it. But what this allows you to do is effectively avoid probate on all your assets that are settled inside this trust when you pass away. So the way this works, and you have to get a lawyer involved, you can settle an alter ego trust and effectively transfer all your assets or any assets that you wish to go inside this trust on a tax deferred basis. So no tax when moving these assets from personally held to inside the trust. Typically, when you do settle assets inside a trust, there's going to be a taxable disposition because there's a change of ownership. Not the case with an alter ego trust. What ends up happening is that now these assets are inside the trust. So during your lifetime, you effectively have access to the income and capital associated with this trust. But upon your death, ultimately, since these assets are not going to fall into your estate because they're under this alter ego trust, they're going to be paid out to the beneficiaries of the trust, not you, but the beneficiaries or alternate beneficiaries upon your death, thereby bypassing your estate and avoiding probate. So an alter ego trust, again, I think is another tool in the toolbox to utilize if it fits you well in terms of transitioning assets into an alter ego trust, whether this be a stock portfolio, mutual funds, perhaps real estate. It's an alternative to using seg funds. But there's a cost associated with it, but definitely can work in the right circumstances. Keep in mind there would be annual tax return filing requirements associated with an alter ego trust, but I do see them come into play typically more in higher net worth situations where clients want to avoid probate upon death and don't want to perhaps explore the seg fund option. This is just another option as well. So keep that one in mind. But really, that is it for my formal comments. I'm going to wrap up here, and I will turn the floor back over and see if there's any questions. I'd be happy to take them. Thanks very much.
Thanks, John. We've got lots already in, and then a couple more that just come in. Why don't we start off with something like a secondary will? So, what would be covered in a secondary will, and why is that useful?
Okay, great. So that's another great point. So that could have been another slide, to be honest, there, Michael. A secondary will is also another way to avoid probate. Okay, but secondary will is typically utilized for business owners. That's where I see the wheelhouse for it. And what you can do with a secondary will, and I should explain the concept really quickly. Everyone's going to have a primary will, where basically the vast majority of your assets are going to fall into upon your death. The primary will is something that you need to submit to the courts for probate. A secondary will typically would not be subject to probate. Okay. And the assets that can go into a secondary will are typically assets that won't be challenged or would require probate otherwise. And and shares of a small business corp would fall into that category. Okay. So for business owners out there, if you're incorporated, that's where a secondary will comes into play, especially again, if your business is worth a lot of money or the value of the shares are worth a lot. Utilize that secondary will to transition those shares from, say, yourself to a spouse or yourself to children without having to pay probate on the value of those shares. Okay. So really that's the wheelhouse for it, as business owners to avoid probate on shares of a corporation. I've also seen situations where you can put personal effects inside a secondary will as well. Jewelry, maybe artwork, things of that nature. You still have to tread carefully with using a secondary will, but again, it can be utilized perhaps for personal effects, again, assets that won't be challenged from other individuals or institutions.
Perfect. And anyone who has a question, if you just put your hand up in the chat forum, I'll unmute you. I'll ask another one, which is one of the most common questions I do receive, which is how about adding a child onto your primary residence in order to bypass probate on the home? Because obviously with the price of houses, probate is a minimum $15,000-$30,000 on most houses.
Great question. And this is a question I also get quite often. And the way I kind of answer this question, Michael, to be honest, is a great strategy if obviously you want your kid to receive that house upon your death and if they live in the basement, okay? Because otherwise you could run into an issue in terms of tainting the principal residence exemption, okay? So if the child, for example, already owns their own property, okay, they already have their own principal residence, which they may or may not, what ends up happening is now they become an owner of two properties, right? So in the future, that could taint the principal residence exemption of the parent because they kind of crystallize the value of the home at that point in time. So presumably, if real estate prices keep continuing, that property will no longer be completely exempt from tax upon the ultimate sale because the kid has become a part owner at any certain time. So although probate would be avoided, you might run into an income tax issue, right? So you got to be careful with it. Obviously the way property values have gone up, and let's say things stay flat for a while or not increase like they have, this might be a good time to do it because you're going to avoid a lot of probate, but just make sure it's not going to be offset or not going to cost you more in tax. There's not necessarily a right answer. You just got to tread carefully. Okay.
It's very tough. We all do our very best to avoid probate because it is a process. It's expensive. It's mentally exhausting going through it, but you can't let that probate tail wag the whole dog, right?
Exactly.
So you don't want to give up your tax exemptions. Now, I guess it's another question along the same lines would be, what about dealing with the tax bill for a cottage?
Yeah. So this is saying at death, for example, if someone owned two properties.
Yeah. So, less than 10 years ago, the main strategy would just be simply sell your primary residence,
yep,
make your cottage your primary residence, and all tax disappears. That option ended 2016 when they changed all the rules. Now, people have inherited cottages from their parents, astronomical capital gains. Other than buying insurance, or what about using something like a forgivable loan and selling it to the children? Can you gift a cottage for $1?
Yeah. So you can gift a cottage. Okay. So let's think of the classic. The best way to explain this strategy, probably the most relatable, is if someone owned two properties today, they're thinking about transitioning it to the kids, the next generation, but everyone's still alive. So number one, yes, you can gift the cottage to the kids. Okay, but they're still going to trigger a capital gain. Okay, because it'll be gifted at fair market value. So that's fine. There's no skirting the tax liability in this case, no matter what you do. Okay, you can gift it. That could work. Okay, so you basically crystallize in the value. All future value is going to go to the kids, which is fine, but the parents are going to be on the hook for some tax as an outright gift. If you sell it for a nominal value, not a good idea. Okay, so you say the cottage is worth 500,000, but you're going to try to give your kids a deal and sell it to them for 200,000. CRA is going to come back and reassess any given time. You never know. They're going to reassess that transaction at fair market value. You're going to trigger capital gains on the difference. And to make matters worse, CRA is going to utilize that $200,000 sales price as the new ACB to the kids. So it's going to result in double taxation. So never do that. Never sell at below market value to the kids. The best strategy to transition wealth, and I have a piece on this, it's actually entitled Keeping the Family Cottage in the Family. It's a scenario where you're going to be selling the cottage to the kids at fair market value, but what you do is you take back a mortgage, okay? So you don't get all the proceeds up front. You take back a mortgage, and let's say there's a capital gain, but since you're taking back a mortgage, you're able to use something called a capital gains reserve. And because of that, you can spread the capital gain on that sale over the course of 5 years. Okay, so not only are you deferring paying tax on the capital gain, you're spreading it across equally amongst 5 years. So presumably you're going to be into a lower marginal tax bracket. Hopefully you're not rating the highest. So I think that's the best strategy, taking back that mortgage, spreading the capital gains over the course of years. And then the kids could actually pay the mortgage to you, or ever how the financial arrangement works out, right, over the course of 25 years with the amortization. But I think that's the best way to do it, or to minimize and defer tax.
Yeah, and basically the capital gains reserve, it's the best, probably the best way to deal with keeping the cottage inside the family.
Absolutely.
What I found is that cottages going down to the next generation is often a recipe for disaster in itself.
Yep.
We've seen legal lawsuits over who gets the master bedroom in a cottage. Right? We've also seen poorly planned strategies where the cottage had to be sold to pay for the tax bill on the cottage.
Yep.
So
absolutely,
a lot of this, the cottage properties, the real estate properties, these are major assets now. And for the most part, the planning has to be done years in advance.
I agree. I think a lot of them now are potentially ticking time bombs, to your point too, with the way the values have gone up over the last couple of years. So the time is now to plan for it, because you're right. Sometimes you're forced to sell the cottage to pay the tax bill on the cottage. There's no other monies to do so. Yep.
Here's an example that we ran into years and years ago, and it's about a non-nuclear family. It was a mother, adult child, remarried, new spouse. So they moved into his home. She had a $300,000 RSP that she named her adult child, 19 years old, the beneficiary of. The husband was the executor of the estate. At her death, her 19-year-old son was paid out $300,000, but the estate owed about $125,000 in tax. The executor is obviously responsible for paying this. What could have been done differently? Because that caused a major friction in this family. Because now the 19-year-old son, it was his stepdad, not, it was always a little bit of friction to begin with. But the father's only recourse is to go back and sue the beneficiary. What should have been done differently in that case?
Yeah, that's a good question. So was there ever it almost kind of go back to my whole concept of choosing beneficiaries carefully, right? Like, what was the intention here? Was there still an intention to provide for the surviving spouse?
No, but the intention was not to have the surviving spouse pay the whole tax bill.
Yeah. Good. So that was not the intention, right? First thing that comes to my mind, again, big RSP. You think about life insurance, perhaps to cover the tax liability with no rollover. Another thing that comes in mind, instead of naming the son the full 100% beneficiary on the 300 grand, perhaps you name him as a 2/3 beneficiary. So he will receive 200,000, right? But 100,000 could go, but the other 1/3 can go to the estate. Okay, so money is there to pay the tax on that RRSP. So it's not completely being eaten by the surviving spouse in this case, or by the estate itself. So sure, the kid has to take a bit of a haircut, but at least there's money there to pay the tax on the RSP instead of creating even more friction at the estate level. So you're playing for it that way. So that's another way to, in my mind, to solve RSP tax problems, is just make sure some money of that RSP goes into the estate. It might require some probate. Oh well, you're not blowing up a family relationship after the fact, right?
And again, like that's an example probably where had they just named the estate the beneficiary and she had a will saying all of my proceeds go to my son, that problem wouldn't have occurred.
That works too. Absolutely. In that case, you're going to be paying a little bit more probate on the 300 grand versus 100 grand in my example. But when in doubt, I guess you can always name the estate the beneficiary, because there's always dangers with naming beneficiaries directly on certain plans. That's why I mentioned in part of my presentation, if you're updating wills, make sure you're updating beneficiary designations and reviewing the overall plan that everything speaks to each other to make sure the end result is reached.
Yeah, and a lot of the times, especially with non-nuclear families, a lot of these assets, yes, they want to take care of the new spouse, but they also want to take care of their biological children and make sure that they're taken care of out of these assets as well. It's very simple for us to update your beneficiary allocations. It's a swipe of a pen. So on a yearly basis, you can come in and say, my $1 million RSP, now I want half here, half there. Now I want to make, like, as the 10 years go down the road, the spouse doesn't need $500,000 anymore. They can reduce it down to 300 or 200. And it becomes a very simple exercise in just updating your beneficiary allocations and knowing where your money is going to be end up going.
Absolutely.
We had a question here about life lease for retirement housing. And John, I don't know if that's right up your alley. It might not be.
It doesn't sound like it right off the top, to be honest.
Okay. So Jane, I'll touch base with you about that at another point. It's not in the realm of this exercise. Majid, I'm just going to read yours out in a second. What about having an executor or power of attorney that's a non-resident?
Yeah, short answer there, Michael. Probably not a good idea for a couple of reasons. Number one, simply from an administrative standpoint. Okay, if you're living in Ontario, living in Toronto, and you pass away, and your executor is living in Vancouver, like your son moved out there, how is he going to deal with your estate administratively, right? He's not in the town to deal with your assets, to meet with perhaps a lawyer, to sell the house, to wrap up your accounts, so on and so forth. So administratively, this is going to be a pain. Number two, an executor, a non-resident or even a non-provincial executor typically needs to be bonded, okay? Meaning there's going to be an issue in terms of having to put money up front to deal with this issue. Okay, so you can also run into some tax problems as well. So long story short, avoid it at all costs. Always a better idea to have a POA and an executor that is close to home, just simply not to deal, again, administratively, and also having to avoid the whole bonding issue. It's not a path you want to go down. Again, I get, sometimes people want to treat their kids equally in terms of, okay, I have two kids. I want them both to be executors. It's an honor to be an executor in my estate. One lives in Toronto, one lives in Vancouver. Well, to me, you're just creating a bigger mess, right? Assuming the kids get along, you're not going to hurt anyone's feelings. I don't think being an executor necessarily is an honor, to be honest. I think it's a lot of work. I always joke, maybe the kid you don't like as much, make them the executor, let them deal with it, right? But in all honesty, keep it local. I just think it's going to make your life easier, or their life easier upon your death. That's kind of the short answer at the end of the day. I get some people don't have the option, but something to think about.
And the wording of that's very important. The wording for an executor between and or makes a world of difference. If you have three kids and it's Bill and Mike and Sue have to do everything together, it's an enormous amount of work for all three parties. The word or is a much better word.
Exactly. Yeah, the jointly or severally, absolutely. And if you have to have another point about that, Michael, you actually brought that up. If you're going to be appointed, and I shouldn't have used the example of two executors, if you're going to have multiple, the recommendation is to have an odd number, 1, 3, 5, especially if they have to act jointly, meaning they have to agree on everything. So if you have two and one says this and one says that, and they don't agree, well, you're kind of at a deadlock. You can always go with a majority rule sometimes, 2 versus 1. You're always going to have, voting power over the other. I've heard that before. I don't know how often I actually see it in practice, but if you're going to have multiple, typically go with an odd number.
One of the last questions, the executor now has a legal liability. They are on the hook for settling all bills. First question, if you have named beneficiaries and there's no estate, nothing's going through the will, there's no assets going through probate, but there are assets that go out to beneficiaries.
Yep.
There's still creditors. What happens? Who's responsible?
Yeah, so ultimately, it's not going to be the executor. Okay, so the executor is never personally liable unless they err. Okay, so for example, if you pass away and you have creditors or you owe tax and so on and so forth, that's not going to be on the executor's. It's not going to be on the executor's dime. The executor is only personally liable if, again, they err or make a mistake in terms of settling the estate. Okay, so for example, they distribute or exhaust the assets and they pay them out to beneficiaries too soon before creditors are paid or before tax is paid. Okay, now they're going to be personally liable because they messed up, right? Always make sure creditors are satisfied, taxes are paid, you get that clearance certificate. The last step of the executorship role, more or less, is to pay the beneficiaries. Okay, I get it takes a long time, beneficiaries aren't happy, but the executor needs to cover their butt and make sure they follow the proper protocol. Now, if you pass away under the extreme circumstance where all assets bypass your estate and avoid probate and there's still creditors that can come to the table, I don't know, to be honest, what the order of operation is there. Obviously, the creditors could have some recourse. Could they go after the beneficiaries directly and demand that they're higher up the scale in terms of they deserve these assets, right? Like challenging a beneficiary designation, which can happen. So if you're the beneficiary of an RSP or a seg fund, but there's a creditor that perhaps supersedes that, well, I think they can go after them and perhaps fight it out in court. Okay. So my classic example is, I kind of go back to the seg fund example, and segregated funds can be utilized for creditor protection, right? And they do work. But for example, let's say I'm remarried and I name my second spouse as a beneficiary of my seg fund. That's the only asset I have. And I die and she gets all the money from my seg fund contracts from the death benefit, but I owe the whole back pile of child support and spousal support to my first spouse. Okay, what happens? Well, my RSA's life insurance policy, my first spouse can technically go after my second spouse and fight it out in court and have that beneficiary designation reversed to satisfy those claims. And there are court cases out there, but the vast majority of those court cases do point to dependency relief claims such as that. I don't know how much case law there is in terms of like general creditors. Okay, like you owe money to, I don't know, Visa or mortgage or banks or a supplier, right? That would be the order of operations. I think they would have to go to court and try to have that beneficiary designation basically undone.
All right, so I've got only one or two more questions. Does anybody have a question? You can put your hand up. I'll unmute you. I've been getting fed these through the chat room. Majid had a question. Shouldn't the RSP even have a named beneficiary go through the final tax process before going to the beneficiary? Because in the end of the day, RSP is a deferred asset. And Majid, that one basically, if you have a named beneficiary, it goes directly to them. Lock, stock, and barrel, the whole thing. The tax bill goes to the estate.
Bingo. That's true. That is actually a good. Just to add to that one, Michael, because I've actually been asked that question coincidentally 2 times this week. Some people are surprised to hear that Manulife or any other carrier for that matter, we don't withhold tax on an RSP death benefit. Okay, so going back to my example I went through, Jason received that $1 million. He's receiving $1 million free and clear. There's no tax withholding from an estate perspective, 0. Unlike if you were to go to your RSP today and make a $1 million withdrawal from your RSP, we would withhold $300,000, a 30% withholding tax. If you do it in life, right? You only have 700 grand, different in death. That death benefit is zero withholding tax. So it's all falling on the estate, but the beneficiary gets the full pot.
Last question I have is, for all these executor questions, there's going to be two major packages that you get after this presentation. One will be the will planning workbook. The other one is going to be the executor checklist or the executor duties checklist. So as the executor, after the settlement of an estate, how long should you be maintaining all of your paperwork and legal documents? Is it your standard 7 years? Is it 3 years?
Yeah, I would probably indefinitely, to be honest. I think that the statute, there's got to be a statute of limitations in there with 7 years. That being said, in Ontario, so remember I mentioned the estate information return. Okay, I didn't get into too much detail with the estate information return for lack of time, but that is a requirement of the executor. Okay, there is no clearance certificate associated with the estate information return, unlike income tax. So with the income tax return, when you file for the deceased, the clearance certificate from an income tax perspective basically says, okay, you're good. Okay, your tax bill is fine. All this person's passed away. We're not going to go after you anymore. From a tax perspective anyways, with Ontario and probate in the estate information return, there is no clearance certificate, which basically means to me there's no statute of limitations as to how far back or how long they could wait perhaps to audit. They say up to 4 years, I believe, but I don't necessarily trust it, because if you erred, they can open it up indefinitely. So just keep the information, like just keep it, right? It doesn't hurt, I suppose.
One more box in the basement.
Yeah, it's one more exactly, one more box in the basement. Absolutely.
All right. Well, that's it on my end. So, John, I really appreciate the time. After this presentation, I will be sending out the slides, the YouTube recording, the 2 workbooks. As things percolate, obviously we'll be in touch with everybody that attended, and this will be part of our planning going forward. Looking forward to seeing everybody face to face. Looking more forward to sitting down with everybody face to face, but we'll get there. And until then, just stay safe, stay healthy. And John, thank you so much for the time. Manulife, thank you guys for helping us put this on.
Okay, thank you for having me. Have a good night.
Thanks, guys.